Attend the court, please. Please be seated.
All right, good morning. We're here today on S-1-SC-39546, Indigenous Lifeways versus New Mexico Compilation Commission Advisory Committee. Can I have entries of appearance, please?
Oh, yes, Your Honor. Sarah Shore on behalf of the petitioners.
Mark Allen and Scott Cameron on behalf of the respondents.
Kyle Duffy and Holly Akjanian on behalf of the governor.
All right. Ms. Shore, it appears that you plan to use 15 minutes for your argument in chief. Is that correct?
Yes, Your Honor.
And 5 minutes for rebuttal?
Yes.
All right. And the respondent and the intervener plan to split their time 10 minutes apiece. Is that correct?
That's correct, Your Honor.
All right. Ms. Shore, you can proceed.
Thank you. Chief Justice Bacon, and may it please the court. The Public Regulation Commission is a constitutional agency with vast authority to regulate public utility companies, motor carriers, and other entities, and to impact the daily lives of New Mexico citizens and the lands on which we live. For 25 years, New Mexicans have enjoyed the constitutional right to direct district-based representation in the PRC. Amendment 1, ratified in the November 2020 election, stripped those constitutional rights from all New Mexicans, including from New Mexico's Native Americans, who comprise the overwhelming majority of PRC District 4, in favor of a political appointment process. This was achieved unconstitutionally. Namely, Amendment 1 violates the Constitution's prescription against log rolling, or piggybacking unpopular measures on popular ones.
Ms. Shore, can I
Yes,
ask a
Your Honor.
question? The election was in 2020. You filed this petition 2 years later, in 2022, seeking this court to exercise its power under the writ of mandamus.
Yes, Your Honor.
Isn't there some sort, or should there not be some sort of a time limitation to bring this kind of a challenge? Let me give you an example. Let's assume you brought it next month. February, after it's fully implemented. Is that too late?
Your Honor, at some point, certainly the doctrine of laches and some sort of equitable considerations might preclude a case like this.
Is this
But-
not that case?
It is not, Your Honor.
Tell me why.
In this particular case, only one aspect of Amendment 1 has yet taken effect, and that is the formation of a voluntary nominating committee that met for the first time in the same month petitioners initiated this litigation. Furthermore,
Doesn't the public interest have something to do with the time constraints?
certainly, Your Honor.
Okay.
However, I think the court has to weigh any potential prejudice or adverse effects on the public against the harm that is posed if the court were not to address what petitioners have claimed on the merits.
Ms. Shore, isn't the public prejudiced by the fact that they didn't, if you are right, they didn't get to vote for a commissioner in this last election, which would have been what would have happened if nothing had changed?
It is true, Your Honor, that I believe 2 commissioners would have run in this election in November. However, the governor has authority under Article 5, Section 5, to make a temporary appointment of commissioners in districts 2 through 5 if the court were to grant.
But it would
relief sought.
disenfranchise the voters that otherwise would have been able to vote in this last election cycle and default to the appointment process and delay any vote or input by the electorate at all for a period of time, correct?
It would delay any input of the electorate for a period of time, Your Honor, but the
Pretty
harm posed-
significant period of time. It's not a couple months.
Yes, Your Honor, but if petitioners are correct, voters were disenfranchised entirely by this amendment, which means that they lost their right to vote for any commissioners whatsoever, unless, another amendment to the Constitution is posed. So really, even if that is the case, the harm posed here, if petitioners are correct, is that all New Mexicans lost the right to vote. And they lost that right through a misleading ballot question and a log rolled amendment that hid the main purpose of the amendment.
So why isn't the misleading, let's take log rolling aside for a moment, why isn't the misleading ballot question barred under the election code?
Well, first, Your Honor, in Clark, this court articulated the standard as the ballot questions must be complete enough to convey an intelligible idea of the scope and import of the proposed law and free from any misleading tendency. And then the court examined on an objective basis the question itself. And that is very similar to the inquiry.
Clark didn't have the timing problem that you have.
And no, that was not an issue in that
And I think
case.
that
But
is Justice Amora's question is how is the language portion of your claim, the misleading language, how is that not time barred by the election code?
well, first, Your Honor, I was actually stating the standard from Clark only to compare it to the standard that we've urged the court to adopt from the state of Florida, for example, which views misleading language in a ballot as violating a constitutional prerequisite to
Why
a
do we
ballot
need to
amendment.
look to Florida? We have our own case law on this issue.
We do on log rolling, and certainly the court can.
We also do on election contests. I mean, why don't we just apply our own case law related to election contests and the timeliness of election contests to your language-based argument in this case? I don't think we need to look outside the state of New Mexico.
I understand your question, Your Honor. I think, first of all, the court can consider the argument about the language of the ballot in conjunction with petitioner's log rolling argument. That's clear from Clark. But also, we are specifically asking the court to recognize a ballot accuracy requirement that arises from the Constitution itself.
And the
That this-
argument there, isn't it, that if it's a constitutional infirmity, you shouldn't be impaired by the election code, right? That's designed for the expediency of an election. If you can argue a constitutional infirmity, should we be writing an opinion that limits your ability to do that based on the timing of the election? Seems to me, no.
Yes, Your Honor, and that's part of what I meant to say about this being a constitutional prerequisite to a ballot
But Ms.
amendment.
Shore, we're not talking generally constitutional, like free speech or something like that. We're talking here, the court's prerogative to exercise its jurisdiction to issue a writ of mandamus.
Yes, Your
And
Honor,
that should certainly have time constraints attached to it, it seems to me.
Your Honor, I fully agree with the court that under certain circumstances, there would be time constraints to a challenge like this brought 2 years after an election, but this is not that case. The main effect of the amendment hasn't gone into effect. A constitutional right was repealed from the people, and this court is the only recourse that the people have in a circumstance like this, where the political branches have transferred a right that the people reserve to themselves to the political branches. The court has to give this special scrutiny because of that.
So what's our standard here? Under New Mexico case law,
Yes, Your
what's our
Honor.
standard?
Clark teaches that the measures in an amendment must share a rational linchpin of interdependence.
And is that consistent with Chavez and Sproul?
Yes, Your Honor. And Clark is the most recent articulation of that standard. I think it's the most refined version of that standard. And Clark really clarified that an overarching theme is insufficient. Measures must have a common objective or purpose, and they must have some measure of interaction or interdependence on one another. And that is to ensure that
What does interdependence mean? I've struggled with that as I've prepared for today. What does interdependence mean if I'm looking at Clark and Chavez next to each other?
Yes, Your Honor. So for instance, Chavez is a good example of interdependent measures because all of those measures had a relationship to each other.
So you're saying interdependence is a relationship as opposed to one being necessary to the other?
Let me take a better approach, Your Honor. I think that the best description of interdependence is not merely that these these measures could not have been presented separately to voters, but it's that a voter might truly support the principle of one measure without supporting the principle of the other, which illustrates that the two aren't dependent on each other, that they reflect different policy goals, and that they're not necessarily
But couldn't that have
related.
been true in Chavez? That the voter thinks, oh, I think it's good to have a nominating commission select judges, but I disagree on the expansion of the Court of Appeals. Isn't that always true when you have a constitutional amendment that touches on more than one thing, albeit under the same category?
Well, I think the other relevant factor you've hit on, Your Honor, which is that potential for a voter to have a principled reason to want one measure and not another, that's evaluated based on the objective of the amendment itself. So in Chavez, the objective was to improve and expand the judiciary. And everything from merit selection of judges to increasing the number of judges to increasing the frequency with which the legislature looks at the numbers of judges and districts, all of those were necessary or incidental to that articulated purpose. And I think it's conspicuous in this case that the only purpose the governor can come up with is the vision of the legislature, whatever that means. I mean, the purpose that was clearly
Isn't
presented
it
to the voter.
reforming the PRC? I mean, that's not,
Right, but-
it's not that difficult to articulate that reform of the PRC is the theme that tethers these things together.
Yes, Your Honor, but reform has a meaning. And I think the governor wants the court to accept that reform simply means change. Reform has a meaning, and the meaning that it was given clearly in the ballot question, in the voter guide, presented to the electorate was to improve the professionalism and independence of the PRC. And these measures don't have that sort of coherence. In this case, Amendment 1 creates more flexibility for commissioner qualifications, including discretion in the legislature to reduce those qualifications. It imposes no professional qualifications or restrictions on the members of the nominating committee. It reduces the PRC's constitutional jurisdiction, giving the legislature discretion to change the PRC's jurisdiction on a political basis. Depending on who you ask, it either makes it incredibly difficult to remove commissioners or it makes them removable at the pleasure of the governor, neither of which appear calculated to professionalize the PRC. And these observations are not second-guessing the legislature's policy judgments. They are necessary to analyze whether, in fact, Amendment 1 has a common object.
But we view it, and I think this is very important, because I understand your point. We want to make here the Native American population lost District 4, I believe it, right?
Yes.
And their voice and representation. But we also have to give deference to what the legislature has now voted as a resolution and the people of the state. And, you know, Chavez and all of the cases in New Mexico make clear that we look at whether the legislature reasonably could have determined that the amendment embraces but one object, as opposed to whether it could be the other way around. So using that as our lens, how do we get past that? Because it seems to me the legislature could have reasonably determined that this amendment embraced one object, one issue, which is reforming and increasing the professionalism of the PRC.
Well, first, Your Honor, the standard articulated in Clark is a deferential standard. It's the standard that requires some common object and an interrelationship among the measures. That takes into account deference to the legislature. And even under that standard, this amendment woefully fails, and not only because of the combination of measures, but because of the ballot question, which Clark explicitly acknowledged contributes to a log-rolled amendment. And in this case, the ballot question didn't just downplay the main effect of the amendment, it omitted that effect entirely. It didn't tell voters that an existing constitutional right to representation on the PRC was being repealed.
But is there any case law that in New Mexico or any law that suggests that we have to tell the voters what's been omitted? You just stated for 25 years they've been voting on the PRC. So I think the voters very well may know that it's an elected position.
Yes, Your Honor, but voters are not legislators, they are not lawyers. When they see a ballot question that doesn't tell them that it is operating to repeal an existing right, they are forced to guess or surmise or simply be confused about what the effect of
On
the...
this point, aren't you really asking the court to overrule Chavez?
No, Your
Aren't you
Honor.
asking us to overrule Chavez?
No, Your Honor, for a couple of reasons. First of all, the ballot question was not an issue in Chavez. So there was no, exacerbation of a combination of disparate measures. But also, Chavez really did have a common objective to which all of the measures interrelated. Every measure had to do with improving the qualifications of the judiciary, improving the overall quality and experience of that branch, increasing the numbers. Every single measure.
It disenfranchised voters as to the initial selection.
Well, it did disenfranchise them. I agree with you that it changed some of the method of election of the judiciary, but it didn't repeal a constitutional right.
So are you suggesting that if a constitutional right is being repealed, that we give it a different level of scrutiny? I mean, I know that at least in the opening petition to us, you advocate for strict scrutiny, essentially, which is not supported by any case law at all. So if you are focusing on this idea of if we're going to fully disenfranchise somebody, that we provide a different level of scrutiny. It seems that that is the undertone of your argument.
Your Honor, to be clear, we think that under existing law, this amendment cannot stand. But I do think that in these particular circumstances, there is reason for heightened scrutiny. I'm not arguing for strict scrutiny standard. However,
what supports heightened scrutiny under our case law?
Well, Your Honor, in our supplemental brief, we cite a number of cases for the
Under our case law.
Yes, Your Honor. I cite in the petitioner's brief in support, I cite a number of this court's precedents for the proposition that if the right to vote is impaired or burdened, the court does apply heightened scrutiny. And also,
We didn't apply heightened scrutiny in Chavez,
no,
which had to do with the franchise as well.
no, Your Honor, but cases are not authorities for propositions not considered, and there's no indication that anyone argued that the court should apply scrutiny for that reason. Likewise, no one raised the language of the ballot in that case. But also, this case presents a unique circumstance where there's a real risk of abuse of power. There's a transfer away from the people who, in their own constitution, reserve rights to themselves, to the political branches. This is not a circumstance where the legislature is proposing to change rights that the people already delegated.
So are you saying that Article 2, Section 1 could not be amended by a constitutional amendment to change the way in which PRC members are selected?
It absolutely could be. Many states have an appointment process, but the voters have to be told that that's what is happening. They have to be told that that is the main effect of the amendment.
So are you stating, you're asking this court to adopt a rule that going forward, if the right to vote on a particular position is eliminated or amended or altered in some way, that the actual ballot question has to include anything that's being taken away or omitted?
I think that's a necessary conclusion from the standard for ballot language articulated in Clark. And certainly when a right is this important, one of the rationales for the prohibition against log rolling is that the legislature doesn't conceal from the public important measures that deserve public scrutiny. And that's precisely what happened in this case. Thank you very much.
Mr. Allen.
Thank you, Chief Justice Bacon, and may it please the court. As set forth in our briefing on this topic, we will be we did not take a position on the constitutional issues related to the log rolling or the vagueness. We're here to vindicate the rights of our client and New Mexicans generally with regard to the lateness of this election challenge. As is uncontroversial in the briefing today, the election code at 114.3 provides a 30-day deadline for challenging election results.
The election code is designed for expediency of candidates and voters knowing who they're voting for and having some normalcy in advance of the election. It seems to me, and if you can address this, it seems pretty constrained if we were to write an opinion that says someone cannot bring a constitutional claim because it was resolved by constitutional amendment through the election. You're basically putting a very short statute of limitation on a constitutional claim.
Well, with respect, Justice Thompson, this amendment was proposed for over 2 years, I believe, prior to it being placed on the ballot. The final form of the ballot was, I believe, put forth in early 2020. So there really was quite some time to consider whether this ballot, and that's what we're talking about here. We're not talking about the substantive changes to the PRC. We're simply talking about how it was presented on the ballot. There was quite some time available in which to mount such a challenge.
But does section 1-14-3 even apply here? It talks about an action to contest an election shall be commenced by filing a verified complaint of contest in the district court. And this here is a writ of mandamus brought in the original jurisdiction of the court. So how does this statute in any way prohibit this court from acting in this particular case?
Well, Justice Vigil, this does not particularly restrict the court's ability to act in mandamus. It's simply to say that the cause of action that's being brought here, which is these ballot initiatives were infirm because they were subject to log rolling and to a vague description on the ballot, that was subject to the 30-day statute of limitations.
Where in that
period.
statute does it say that?
It does not say it in the statute specifically related to the mandamus relief.
Before I lose my thought, it seems like what you're trying to do is parse this statute out, say this part doesn't apply, this part does apply, and this part doesn't apply. And you're saying that the 30 days is the part that applies.
I apologize, Justice Vigil. If you could clarify what part of the election code you believe I'm saying does not apply to this determination.
Mandamus.
The fact that it doesn't reference mandamus specifically? Well, Justice Vigil, I believe that it is simply saying that the cause of action itself, the challenge, must be brought by an original action in district court. That's how I read that language, Justice Vigil. So I do understand your question. Thank you for it. The issue here is that, this is not a constitutional challenge to the text of the law. This is a constitutional challenge to the wording on the ballot. This is, log rolling and the vagueness of the ballot initiative can only exist within the context of an election. To say that this election code applies to any challenges other than constitutional ones would pretty much gut that statute of limitations. There are any number of challenges to elections that are contained in the Constitution rather than by statute or some other means. Log rolling is simply the coercion, the evil prevented by the ban on log rolling is preventing coercing voters into voting for something, a second measure because they support a first. The issue is determining the will of the voters. We have a mechanism in place for addressing concerns related to the.
They're not challenging whether the amendment passed or didn't pass. That's not what they're challenging. It's not an election contest. So I think you can sense my frustration with that limitation. Tell me a little bit about latches. Do you assert the latches argument?
We do. We did not assert it in our original brief. We believe that it was raised by the interveners, and we certainly think it applies here.
Tell us a little bit about that, because I am curious. It does seem it's pretty late in the game here, and in particular the prejudice prong to me.
Well, absolutely. The prejudice here, and I believe that the governor can address this a little bit more, knowing a little bit more about how the PRC is going to be constituted under the new regime. But obviously, we've had, we're well down the road of constituting the PRC under the new regulations. Voters have been denied, as Chief Justice Bacon pointed out, an opportunity to select or would have been denied an opportunity to select their commissioners. And the prejudice is also with the voters. We have to presume, this court has to presume at this point that the amendment as passed reflects the will of the voters. This is
Don't
what
we
they
have to
wanted.
balance whatever articulated prejudice there is? I mean, there's no inability for your client or the governor to defend against these claims. I mean, that's usually the flavor of prejudice in a laches challenge. We're not so far removed that has impeded anybody's ability to be here today. But don't we also have to balance any articulated prejudice on the respondent's side with the importance of the public right at issue?
I certainly do, and I think that part of
And
that.
doesn't that undercut your laches argument? Because here we're talking about disenfranchising a significant group of voters.
Potentially, Justice Bacon. I believe that the concern for resolving disputes regarding elections and achieving finality with regard to certified election results is also weighs in favor.
Is this really a challenge to the finality of the election? Isn't this really a challenge to the constitutionality? And isn't that an important distinction here for purposes of our analysis under the election code?
Under the analysis of the election code, I do not believe so, Chief Justice Bacon. I believe that there was a time available to raise this claim, and there are democratic options that are available for rectifying the perceived ill. Again, there is no charge being raised that these provisions themselves are unconstitutional or that they're depriving New Mexicans of some other right. It's simply that the way they were presented in the election was improper because it was vague and because there was log rolling allegedly. So no, I don't believe so. I think that the petitioners have not been able to cite any case law to support their position, and they have a heavy burden to persuade the court that a writ of mandamus is appropriate here. Clark, as the court has pointed out, was a timely filed log rolling challenge, filed within, in fact, before the election results even had been certified. Sproul predates the section of the election code that we're addressing here today. It was decided in 1967. 1971 is when this 30-day.
So we should leave something, assuming that I agree with the petitioner that this is unconstitutional, we are forced to leave it in place because of the timing.
That is our position, yes, Chief Justice.
That's a pretty extreme position to tell the Supreme Court of the state of New Mexico to turn a blind eye to that which might be unconstitutional.
And if I could add to that question, if it's a normal log rolling, and we get log rolling questions all the time, we would be able to hear it. So you're saying it's time barred because it's a constitutional provision. We have log rolling statutes you could bring way past the election code.
Well, perhaps I am asking the court for extreme relief here, but this is vindicating a contravening right of the people to have their vote count. I understand that.
But we'd be barring it we wouldn't be hearing it on the merits, which is the right of the people versus petitioners' arguments. You're just basically saying the election code bars any challenge to any election, regardless of its constitutionality. Is that right?
I believe that the election code bars any challenge to for example, the substance of the ballot as it was presented to the voters after that 30-day period, regardless of whether there was a constitutional infirmity of how it was presented. Yes, that is our position. I see that I am out of time. If there are any further questions, otherwise I will cede my time.
Thank you very much, Mr. Allen.
Thank you.
Mr. Duffy.
Chief Justice Bacon, and may it please the court. We're here today on the eve of the transition to the PRC because petitioners waited 2 years to challenge the results of the democratically held election. But the court need not and should not grant such extreme relief of overturning the will of the voters for 3 reasons. First, the petition was untimely, and granting it at this juncture will affect prejudice on the people, the legislature, and the PRC itself. Second, the measures of Amendment 1 all rationally relate to the legislature's vision of a more efficient and competent PRC. And lastly, the ballot question was not misleading because it explained its chief features to the voters, and petitioners cannot prove that even one voter was misled. Now, moving to the
Can I interrupt? We have limited time. The joint resolution on the amendment, it says to amend the Constitution to provide that the Public Regulation Commission consists of 3 members appointed by the governor from a list of professionally qualified nominees submitted to the governor by a nominating commission. And that the commission is required to regulate public utilities. And it may be required to regulate other public service companies. It seems to me that there are 3 separate independent proposals in that title. Tell me what I'm missing.
Yes, Justice Behill, that's a good point. However, if you can compare it to the measures at issue in Chavez, one could also argue there were many independent measures in there. But what the court did was defer to its sister branch in the determination that those incidents and measures, those were merely incidents related to the chief purpose, which was reforming the judicial branch in total. And I will get into the legislature's precise intent.
But in Chavez, the constitutional amendment did not redefine what the jurisdiction was of the various courts. And that's what this does here. It not only defines how you're going to pick and who's going to be on it, but it redefines the jurisdiction, not in one way, but in 2 different ways.
And doesn't that make it more like Clark? Because Clark has the and provision as well.
Respectfully, Your Honors, I would disagree. I mean, Chavez also had other measures such as how that are not included in Amendment 1, such as how chief judges and justices are selected, the qualifications for the judges and justices, allowing the legislature to create more judges and judgeships and districts.
But was any segment of the population, did the voters lose their right to have a say in who their judges are? As they do here, they're losing their right to determine who they want to represent them in districts that are divided in ways that all communities in New Mexico are represented.
That's correct, Justice Zamora. They did not lose their ability to vote for the judges. In fact, they gained the ability to vote. However, I believe that's a distinction without a difference here, because petitioners cannot cite any authority for the proposition that the court should invoke some sort of higher scrutiny in this context. Every case from this jurisdiction and from other jurisdictions I could find say that the court should give substantial deference to the legislature in determining what constitutes a single object. Indeed, in Florida, in some of the previous cases before Armstrong, they also had amendments that would change, for instance, the 4th Amendment equivalent under the Florida Constitution, and they did not, I do not believe, applied any sort of heightened scrutiny, and they upheld that measure there.
How does this measure survive the review spelled out in Clark?
Yes, I believe it survives, even if the court were inclined to keep that and to not stick with the Chavez language. I think this measure would survive that because these measures do have that rational linchpin of interdependence. Now, I had
what does interdependence mean? Is wrapped up in
yes,
my question.
Right. I agree that according to the definition in the dictionary, they're interdependent. They are dependent on each other. However, that does not jive well with this court's precedents, especially in Chavez. And so I think the key is to look at whether the legislature could reasonably determine that these measures relate to the same general object. And in this case, it is.
But in Clark, the court could have said both measures there related to gambling,
Yes,
but they didn't.
yes, and I agree that that one cannot simply choose a very broad topic, and you know, if you choose such a broad topic, you can have almost anything related. But I believe these measures are sufficiently related. First, the legislature, I had the pleasure of listening to the debates, the legislature over the Thanksgiving holiday, and here's what I learned specifically. Yes, I have
Happy
weird hobbies.
We suffered the same problem.
First, the legislature wanted to create a more competent PRC by requiring them to go through a triple vetting process through the nominating committee, the governor, and the Senate, rather than winning essentially a popularity contest at the ballot box. Second, the legislature wanted to reduce the amount of commissioners for a few reasons. First, they wanted it to come in line with other states' PRCs, which were smaller. They also believed that it was an easy number to stagger with 6-year terms, which the legislature believed was necessary in order to ensure that no one governor could appoint more than 2 out of the 3 commissioners. The legislature also believed that a smaller commission would be more efficient and potentially more amicable, but we'll see about that. And they also believed that it was wise to free up the resources that would go to those 2 additional commissioners and use those to give the commission more support staff. And in terms of the PRC's jurisdiction, the legislature wanted to streamline it to give the legislature more flexibility in determining what entities and areas the PRC should regulate as technology advances and society changes, instead of having to enact a constitutional amendment each time. For instance, in the previous iteration of the amendment, telegraphs were still regulated by the PRC. And so I would argue that all of these measures are joined by a rational linchpin of interdependence, of creating a more competent, yes.
I think council's maybe going to get up in rebuttal if there's time for rebuttal. And so you've talked a lot about what language is in there. I think one of the concerns is what language is not in there. And they advance an argument that if you're going to take an existing right, that is the right to elect rather than the governor to appoint, that must be specifically spelled out. I could not find any authority for that exact concept. Do you have any thoughts on that?
Yes, well, I believe it was in essence spelled out here. While it's undisputed, the ballot question did not say you will lose the right to vote for this. I believe that common sense dictates that by the ballot question telling the voters that the governor would be appointing these commissioners of this commission that has been around for decades, that it was implicit in that if the governor is picking them, the electors are not. So I don't believe this is a case where the legislature was hiding the ball and no reasonably prudent voter couldn't understand that they were losing their right to vote. I believe that was pretty explicit in the ballot question, as well as the other changes, such as reducing the amount of commissioners and changing the jurisdiction of the PRC.
So let me ask you this. If a voter, why isn't it log rolling if a voter strongly supports reducing the amount of PRC members and limiting its jurisdiction, but opposed giving up its ability to choose who represents them? Why is that not log rolling? Why is that not giving the voter kind of you eats all or nothing?
Right, yeah, that's a good question, Justice Zamora. And I would say that could be argued in almost any constitutional amendment. It's very rare that there is just one explicit change in the amendment. For instance, in Chavez, again, going back to that case, it could be argued that that maybe the people wanted more judges, but they didn't want to create the judicial nominating commission, or they want one measure or the other. The key is to look at the vice that it was log rolling was meant to address, and that's that is the legislature attaching one very unpopular, or a more unpopular measure with a very unrelated popular measure in order to coerce the voters into voting.
And isn't that the real point of Clark?
Yes, yes, and I believe Clark is a great example of that. They joined the popular measure of the state lottery with the less popular measure of kind of flying under the radar of the various video games of chance. Whereas in this case, I would argue this is much more similar and in fact more targeted than the measures that were upheld in Chavez. Now, going briefly to the ballot question, I would point out that petitioners have provided this court with no evidence that a single voter was misled, let alone the nearly 100,000 voters that would need to have been misled in order to create another result. And furthermore, this court should take notice of the public debate and intense scrutiny, and as well as the official guidance that was promulgated by the Secretary of State pursuant to the Constitution in the months leading up to the election, which other courts from other jurisdictions have taken notice of and held that it could clarify any potentially confusing language in the ballot question. Thank you, Your Honors. If you have any more questions, I stand for questions. If not, I see my time is up.
Thank you very much.
Thank you.
Too short.
I thank the court. If I may touch on just a couple of points raised by the Governor's Council and the Attorney General's Office. First of all, Justice Thompson mentioned items that are omitted from the ballot. And I would like to emphasize to the court that Clark actually said that ballot questions should be free from any misleading tendency, whether of amplification, of omission, or a fallacy. And Clark didn't consider that voters should have been educated enough that they would have understood that the phrase certain games of chance referred to a private right to wager on video games of chance. And the court also didn't engage in an inquiry of exactly how many people this ballot succeeded in misleading. The question was, on an objective basis, whether the question was misleading. And in that case it was, and in this case it is.
Why wasn't it misleading in Chavez?
I don't think that the ballot question in Chavez would stand up under the standard articulated in Clark, but that wasn't addressed in Chavez.
So are you, again, going to Justice Vihill's question, are you asking us to overturn Chavez?
I don't think you have to, Your Honor, because no one argued that the ballot question in Chavez was insufficient. It wasn't before the court. The issue was not before the court. And in this case, we are arguing that the ballot question, as in Clark, contributed to the log rolled aspect of this amendment. And it's illuminating to go through how many things are missing from this ballot question, including which parts of the Constitution are being modified, the repeal of an existing right to vote, the repeal of an existing right to geographic representation, repeal of large areas of the PRC's constitutional jurisdiction.
So are you wanting us to write an opinion that says that the title of the constitutional amendment has to reflect all of the items that are actually going to be changed in the Constitution?
No, Your Honor, I'm not
Then how do
arguing.
we avoid every constitutional amendment falling short due to omission if we don't put all of it in the title?
Your Honor, what Clark requires is an intelligible idea of the scope and import of the proposed law. So I'm not saying that every single omitted detail should have been in this ballot question, but certainly proposing to repeal the right to vote for commissioners from geographic districts of the state. And
isn't that apparent by changing it to the governor will appoint?
No, Your Honor, because it doesn't disclose to the voter that a vote in favor of this amendment is having the effect of repealing their existing right to vote.
So can I ask you, one of the things I read in, I believe it was the governor's brief, was the fact that there was only the one affidavit. There's no actual evidence. We're speculating a lot about what the voters did or did not understand. I mean, we're saying we don't think they knew that they were giving up their right to vote. We're speculating a lot. I'm wondering if you think we should have there should be actual evidence as opposed to speculation about what the voter did or did not understand.
Your Honor, I don't think the court is speculating any more than the court in Clark was speculating about that ballot question being misleading. And that's because, in effect, the court asks, what would the average voter have understood from this ballot question? And that's necessary because it would be incredibly difficult. First of all, I don't know that it would be amenable to proof to even try to undertake to find out how many people were successfully misled by a ballot. But also, the branches of government can't abdicate their responsibility to articulate with a minimum degree of accuracy the changes being effectuated by an amendment. And I would like to actually draw the court's attention to a quote from Clark versus Johnson, quoted by Justices Thompson and Bacon in their dissent in Pirtle versus Legislative Council Service, because I think it highlights the important role of the court in addressing this issue. That state constitutions are not grants of power to the legislative, to the executive, and to the judiciary, but are limitations on the powers of each. No branch of the state may add to nor detract from its clear mandate, and it is a function of the judiciary, when its jurisdiction is properly invoked, to measure the acts of the executive and the legislative branch solely by the yardstick of the Constitution. And here the Constitution requires that when a constitutional amendment is put on the ballot, voters are given the means to fully and accurately express their will on each and every issue presented.
So let me ask you this, we still have there's still room for your clients to address any concerns of this nature through the legislative process now, right? I mean, the legislature, I believe in this amendment, gave itself, and the people gave it, power to kind of define what the PRC commission will look like and things, its jurisdiction. Can't some of the concerns of your clients be raised through the legislative process?
Well, Your Honor, I think the issue is that the people reserve to themselves the right to direct representation in this constitutional agency. And the legislature took that away without telling them that that's what was happening. They didn't delegate to the legislature responsibility to elect PRC commissioners. They reserved that to themselves. And so although in theory, they might be able to advocate through their representatives to change that, they shouldn't have to go through that time-consuming and uncertain process when the way that their rights were removed was
So
unconstitutional.
how would you write the title to this constitutional amendment to make it constitutional?
I think it would have gone a good distance for the ballot question to begin, proposing to amend Article 11 of the Constitution to repeal the right to vote for PRC commissioners from geographic districts of the state, and continuing the way the ballot question read.
Then in that situation, the and would be unnecessary. Right?
Your Honor, I'm
So
simply.
you're saying that you would have preferred to say that the right to vote is repealed, that the right to vote as it is heretofore existed is repealed.
Yes, Your Honor, I'm simply saying articulating a disclosure that would have made this ballot far more accurate than in fact it was, which was to alert the voter that it was acting to repeal existing constitutional rights. Thank you very much.
Thank you. All right, council, as this is an extraordinary writ proceeding, we will endeavor to retire and provide you with an answer to the question. If we cannot reach some semblance of consensus on that, we will notify the clerk, who will come back into the court and let you know that you can carry on with your day while we try and sort this out. But in the event that we are able to reach a conclusion, we will come back and announce that in open court. So we'll ask you to stay here. Okay, thank you.
Attend the court, please. So council, the court will be coming out pretty shortly. We are going to be like on live stream shortly.
Our meeting now.
Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. So first, thank you for your presentations today. They were quite helpful. On the petitioner's verified expedited petition for writ of mandamus, directing removal of Amendment 1 from the New Mexico Constitution, the court has concluded that it's appropriate to deny the writ. The question before the court, we do not believe, is barred by the election code. But further, the court has concluded it is not log rolling either. A written opinion will follow, explaining our rationale on those two items and other issues of import raised by the parties. That will come in due course, but we wanted to get you information as quickly as we could because of the time sensitivity of the petition before the court. So thank you, counsel. And the court will be in recess.
Attend the court, please.